Welcome back, Scott Trout, managing partner and CEO of Cordell and Cordell, and welcome to the Men's Divorce Podcast Live. Yes, new name. We're going to be rebranding as starting today, the Men's Divorce Podcast Live, rather than virtual town hall. Virtual town halls, we started back in 2020 during COVID, and just makes it more sense for us to continue on our podcast and post it on YouTube Live, as well as on our YouTube channel at Cordell, as well as Men's Divorce Podcast Live, and you can subscribe to it. So today is no different, but we're actually going to talk about a very interesting, maybe two topics, maybe the two worst topics to talk about. That is divorce and taxes, things that no one wants to deal with, no one wants to talk about. But keep in mind, if you have questions, submit those in the Q&A section as we go along over the next 25 to 30 minutes. We'll try to get your answers to the questions that you have. But go ahead and subscribe to the podcast, to the Men's Divorce Podcast Live, so you can stay up to date with all of the guests that we have. And today is no different. But also keep in mind, as I always caution during our podcasts, that this isn't legal advice. We can't do that via a podcast like this or even our previous town halls. You have to schedule a consultation with an attorney who practices exclusively in family law or tax law, like today's guest as well. You can do that at cordell.com. You can go online and schedule it right there. You don't even have to pick up the phone. You can just type in your zip code or your city. It'll take you to the nearest office closest to you. You can schedule that via Zoom, in person, whatever works for you, telephone, or you can give us a call, 866 Dad's Law. But go ahead and submit those questions in the Q&A section, as we're going to talk about taxes and all things relative to that and family law, because it comes up quite often in terms of dealing that. We are really honored to have a guest today. So let's introduce our panel today. And our special guest is Hubert Johnson with Guardian Tax Law. Welcome, Hubert.
Glad to be here.
Well, thanks for joining. I'm really excited to have you on here, and we have a lot of questions for you. We're going to be firing away, and that brings us with our attorney, lead litigator in Georgia, Deanna Potter. Welcome, Deanna.
Hi, thank you, Scott.
Well, we're looking forward to answering your questions and getting to some of the topics that we think affect everyone in family law, and try to give you the right direction and information. And that's really what we're here to do during this live podcast. So before we get right to it, again, don't forget, submit your questions in the Q&A, whatever they are. We'll try to get to those. Let's take a real quick break. We'll be right back. All right, welcome back. Let's get to it. Hubert, let's just kind of go right to you. It's fortunate that we have you as not only someone who can be talk to us on an expert level about tax, but you're also an attorney. But give us a little bit of your background, especially with Guardian, and what you do, where you're located, what services you can provide. And I know it's guardiantaxlaw.com. Is that the website?
That is the website, yes.
All right. So go ahead, tell us a little bit about yourself.
So I've been doing this for about 14 years. I kind of fell into tax law and it has turned into my passion. So I've taught graduate tax law at Brewer College in New York. I've lectured at seminars in New York, California. I've done trainings for tax professionals, teaching them how to do this work as well. I've co-written 2 books on the topic as well, all about how to handle and deal with IRS and state taxes.
Yeah, it's so complex. I was thinking, it just, everyone complains about taxes. Everyone complains about filing taxes. And it gets even more complex when you get divorced and you're separating assets and you're dividing property and you're dealing with, 401ks or marital homes, and you're transferring it, and it makes everyone a little nervous. And, what are the tax implications? Do I have to pay taxes? Or if there's a tax debt out there? I mean, it can go on and on. So let's kind of just start there, Hubert, in terms of what should people who are separated, getting divorced, what should they be thinking about? What should they be expecting, worried about, inquiring you, calling you, saying, hey, I have questions? What should they be kind of topics that they should be thinking about?
Well, again, who's going to claim the kids? Who's going to claim? We already have a question about mortgage interest deductions, and those can be claimed by whoever chooses and what's put in the MSA. And that's the interesting thing, is that the attorneys, when you go in and you start negotiating, first thing first is protect yourself, file separately. If you think they're going to owe or have problems on their taxes, separate your liability out from your spouse. And that would be my very first suggestion, is and find out what's going on, especially if the other person has managed the finances. That's what the biggest problem I see, is where someone is just working, or they're doing their thing and they're not the one handing the money. They're the ones that get blindsided. So you can easily find out and dig in and see what's going on, what has happened, and go in with being informed.
So what kind of things do you handle at the Guardian Tax Law? I know there's things where we talk about offers and compromise. What services can you envision perhaps divorced parties needing? They may have a tax debt that's sitting out there.
Well, there's quite a few.
Mm-hmm.
It's a very narrow niche, but there's a lot in it. First of all, number one thing is who's liable for the debt.
Mm-hmm.
If someone has a business, what's going on? Will that incur future liability? And planning as you go through the divorce to not only avoid liability, but avoid complications, because the truth of it is that the IRS doesn't care what the attorneys and the judge agree to in the marriage settlement agreement.
Right.
They'll go after both parties jointly and severally. And so having that mindset and understanding where the IRS comes from helps you plan to avoid issues. And so if one person is going to flake on a debt, include that, I would assume that debt and then take on more assets from the marriage to compensate you for that. So there's ways to plan for it. Tax liens on property that need to be sold. We release tax liens, and we can also do offers and compromise. We do those all the time, as low as $20 to wipe out tens or hundreds of thousands of dollars of debt. We usually get a couple of those accepted every week. But it has to be personal to whoever is being represented. And it depends on, are the parties working together or not? And if not, you've got to protect yourself.
So if parties do owe a joint tax debt from jointly filed returns, would they be able to potentially negotiate separately with the IRS for his or her portion of the debt?
They almost always have to negotiate separately if they're living in separate residences. Now, I have had cases where we were setting up installment agreements and one party was assuming those payments, and then we were able to include both of them on one installment agreement. But if one party doesn't pay, then the IRS will still pursue both parties. So again, be aware of that. Even if you set something up, protect yourself just in case the other party does not fulfill their obligations, what they said they're going to do. For an offer and compromise or a hardship status where the IRS can't collect from you at all, those have to be done separately.
And I want to talk a little bit about, you mentioned earlier, exemptions, child tax deductions. I want to talk about that in a minute, but I want to stay on this topic of perhaps debt to the IRS, which I find, it's so interesting, that kind of collaborating with experts like yourself. And that's so necessary in family law, where, for example, you may have a spouse may realize that there's this debt that may be sitting out there that they weren't unaware about of. And so you had mentioned earlier about filing separate. There's innocent spouse kind of, many of our clients have mentioned this innocent spouse theory. How does that even work?
So like most abatement processes, it is hard to qualify for innocent spouse. So a good example, this actually happened to a relative of mine where he was a truck driver. He was on the road all the time and his wife embezzled money. There were separate accounts. He didn't see the money, didn't benefit from it, and he was in the clear. But if you receive the money, if the money comes into the home, you don't even have to know it's being done illegally or that they're not paying taxes. It is hard to get innocent spouse approved. You really have to have no benefit from the money and no idea it was going on or reason to know. So it is actually a very difficult thing to do. People do apply for it all the time. We have got it granted, but it's a pretty narrow exemption with the IRS, or difficult application to get approved.
Yeah. So
And is
there's,
that,
go ahead.
I'm-
No, go
Scott,
ahead.
excuse me, so would that be something that if we do have a client who is contemplating potentially filing for an innocent spouse application, would that be something that we would, refer to a tax attorney? We would want them to handle that, or is that something that they could potentially do on their own?
They could always do, just like,
Yeah,
well, they can do it on their own, but do they know what the IRS is looking for? Do they know what the standards are and how to present it? That's the difficult thing, is you can always, and I see some people that are pretty savvy that can look things up and apply for things on their own, but call and get some advice. If nothing else, we don't charge for our consultations, or consultations are just a few $100s. It is well worth its weight in gold to get some basic advice, because I see people mess up. Just a quick example, I had one gentleman call me and he was so excited that he got current with the IRS and filed 23 years of returns and was completely caught up. The IRS only can demand he goes back 6 years.
Wow. Let me
Mhm.
ask you real quickly, as we're kind of moving along, we have questions coming in, so keep submitting those in the Q&A section. We'll get to those in a second. Let's talk about you mentioned earlier, the tax credits exemptions for children. What is it that those people going through divorce, you kind of alluded to it, that's something to be discussed. How does it work? How does it apply? What should they be thinking about in negotiating, whether it's head of household or taking deductions when they're thinking through that?
So keep in mind, and this is what I've seen, and you have the plans, you set things out in the MSA or the marriage settlement agreement. You've got to imagine that they're not going to do what they say they're going to do. I don't know how many times someone comes to me, oh, they agreed, they said they weren't going to claim the kids, and then they started claiming the kids. And so you're smiling, you see that all the time. Assume they're going to claim them. Assume they're not going to file it, because what happens is when technically the person that provides 50% or more of their support, usually who has majority time with the children and they live with the parent the most, is the one that should claim the kids. Now, is the IRS going to get involved in the details of who should claim the kids? Almost never.
Yeah.
That's the truth of it. So usually it's whoever claims them first. If you have someone that has no contact with the kids and starts claiming them, yes, you can go in and fight it. You can present all the evidence to the IRS and they can change their determination, but usually it is a hard thing to do. It is a pain. But when you have someone that's not paying support, that's not connected to the kids or involved in the kids' life, sometimes you have to do that. But if you have someone where child support is being paid, it might be advisable, especially if you think they might do that in the future, to just let the other party claim the kids and then lower your child support and alimony or spousal support. Because I see it happen all the time that the 1 year off, 1 year, they claim the kids alternating years, and then someone starts claiming them every year.
Yeah.
Your options are go back to court and fight over it again and family law court, or try to hush it with the IRS, and the IRS really doesn't care. They've got bigger fish to fry.
Now, is there a way to divide? It's say one parent wants to claim head of household and the other can take the deductions for the children. I know that that's a question that comes up quite often.
Usually the deductions follow whoever's claiming the dependents.
Okay. So let's just jump real quickly to a question that came in early on, and I know you alluded to it, and you said, are taxes paid for a quitclaim deed, are they deductible? And along with the mortgage, are those interest payments deductible?
They're deductible just like any other mortgage interest payments, and you can decide that between between the parties, who's going to claim those deductions. You can split it half and half. That really is something that can be decided, and as long as the parties follow it and don't try to claim the whole thing, you shouldn't have a problem. But again, I think it's preferable that one person just assume the house, is making those payments, and that person get the deduction. That way you're eliminating the options for funny games. If someone claims it and they're not paying the mortgage, that's pretty easy to show the IRS, hey, I'm the one that got the 1099 for this.
What about if the parties aren't yet divorced, but they still own the house at the end of the year? Is that kind of like a whoever files first type of situation?
Well, if you can always file separately, even if you're married, there are plenty of married couples that are happily married that file separately. So if they're going to file separately, I would take and either split it half and half between the parties, or let one person do it, whoever's paying the mortgage, let them claim that, and then give the other party more assets.
Oh, so they can split it up between the two of them if they do file separately?
Yeah, the IRS will follow the division that they agree on, as long as one person, they're not both claiming more than their share.
So there's always the question as well, for years, alimony, maintenance, spousal support was deductible by the payor and includable in income by the payee. And that changed obviously with the revision of the tax code. But they also ask whether or not child support is deductible. Can they claim that as a deduction when they make those types of payments?
Not anymore.
Mhm.
So that stopped in the same year, I believe it is 2018.
Yeah.
But it is important to keep track of that. So that was one of the questions we got early on. If you are paying alimony, if you are paying child support, it is very important to keep track of it, because if you do owe taxes, it's what's taxable and what's taxable when you're filing your taxes is very different than what qualifies as an exemption when you go to collections and you're negotiating a resolution with the IRS, an installment agreement or hardship or an offer in compromise. So keeping track of child support payments is very important in alimony, but also just in case anybody comes in questions, if your spouse ever comes in questions, did he really pay me? If you have those records, you can take it to court. Otherwise, you might be paying the same amount twice. I imagine you've seen that before.
Right. Which goes in line with attorney's fees. There is a provision that allows for some deductibility depending upon what the attorney's fees were incurred for. Because I know clients say, well, you just charged me X. Can I, write that off on my taxes? Under what circumstances is the IRS consider this an allowable deduction?
So this is more of a CPA question, and I'm not a CPA, but the plain answer is, if you're protecting, or if you're trying to get property and assets, then you can write off those legal fees for that, not for pursuing child support, but you can for alimony or for property. So the legal fees to get those. So just a quick reading of the law: if you're defending that and fighting against that, you don't get to write those off.
What about is there any deduction for child care, for payment of child care?
On your tax returns?
Mhm.
That I don't know. That's a CPA
Yeah.
question.
Okay,
But childcare does matter if you're going into negotiations with the IRS. That absolutely does matter.
So you mentioned earlier, in terms of the look back the IRS can do, that one of the questions that came in was the 3-year, he mentions a 3-year limitation to amend and receive refunds. Is that something that is absolute? And I'm not sure that actually is the timeline for amending and getting refunds.
So you can amend anytime.
Okay.
But to get a refund, so if you didn't file a return and you were owed a refund, or if the IRS didn't went and filed for you, it is a hard rule that 3 years, you can get a refund within 3 years. So if you go further back, let's say you file something from 2019 and you were owed a refund for that year, it's too late.
Gotcha.
You just won't get it.
Which, I just finished a case where, as you suggested early on, the parties filed married separate during the pendency of the case, and this lasted 3 years. We negotiated after sitting down and realizing that our client was really the high earner, and it was beneficial for them to file married joint, not separate, and then divide the refund accordingly. I assume that's something that you were alluding to, but thinking about married separate, does it always make sense to go married separate, or what was the reasoning behind that?
Filing married, filing separate, it protects you more than anything else. And attorneys too often want to protect their client. If it makes sense tax-wise to do married filing joint, but if they have a business, if they've been the one controlling the assets, do your due diligence, look into your taxes, see if there's a history of non-compliance or owing taxes. And if you feel confident that there isn't anything, you can file married filing joint until the divorce is final. The problem is, and this is, I see the problem cases where, someone had a business or they weren't paying taxes, et cetera, and they didn't know that they weren't paying the taxes. And sometimes the other party didn't have reason to know that they weren't paying taxes. Or one person managed all the finances and just stopped paying taxes for the household. Those are the cases I see But if someone's confident, they know what's going on with their finances, they know the income of the other party, they should be fine. But again, I see the problem cases.
And generally, oh, go ahead, Deanna.
So often I get questions from clients where, say for instance, whether it's my client or the spouse, where they filed jointly, but the party says, oh, I didn't sign my name. My husband signed my name to that. My wife signed my name to that. Is there any defense for that?
Absolutely. So basically you would file for fraud
Okay.
with the IRS, and because even if you don't sign the tax return, you do have to sign an authorization to e-file. And if both parties don't sign that, technically you can go in and allege that the person didn't have a clue. But if you it's pretty common where one person goes in is handling the taxes and they're doing it and the other person is kind of oblivious. If you have the client that doesn't know what's going on, that's why they need to dig in and find out what's going on. So you have to make that argument. It is long. It is not easy with the IRS, and you will have a fraud identifier placed on your account where you have to use a PIN to file your taxes, et cetera. It just makes it more difficult to deal with the IRS moving forward. But if there truly is fraud, it's well worth it.
You mentioned early on about the IRS not caring necessarily about who may or may not be allocated the debt. And there's a question early on about whether or not divorce decrees override federal law regarding taxes, and does the IRS really care? They don't, right? They don't care what
Not at all.
So if let's just say husband agrees to take all of the debt, and it was all IRS debt that was incurred and accrued during the marriage, they're going to go after whoever they can get it from, correct?
Absolutely. And that's where I see a lot of people get very frustrated. It wasn't my debt. I'm not liable for it, or I shouldn't be liable for it. And shouldn't and are liable for it are two different things. The IRS will pursue the parties, take the money where they can, and then let them figure it out between themselves, either in probably divorce court.
Right. Absolutely.
Which is messy.
It is. And, we have this situation quite often when we have either small business owners, entrepreneurs, whatever it may be, where they incur some debt, and it could be substantial, or it's a future, liability potentially based upon how they're keeping their books. And trying to explain that to a client is like, look, it's the IRS does not matter what we do here. So just be aware that we can have all the hold harmless language we want in a marital settlement agreement or a divorce judgment. The IRS just doesn't care. If you've got available funds, they're coming to get you.
And you can protect them. There are ways to prepare for if you know something's coming down the road, but it makes a lot more sense if you have the more responsible party to assume that liability in the marital settlement agreement, and then get funds to offset that, marital funds to cover that.
One of the questions is, explain really what head of a household is. We talk about that. We tend to, as lawyers, use terms that we know regularly, deductions, child tax credits, head of household. What is the head of household?
So head of household is where you have dependents. You're providing for the home, but you're not filing jointly with someone else. So you have dependents in the home, but again, you're not. And you can be filed single, but there are tax advantages to filing head of household versus single.
Mm-hmm. And the head of household, the standard child deductions, can you claim both at the same time? I know it may be a CPA question, but I think you said earlier, those follow whoever claims the head of household?
It claims whoever claims the dependents. Well, follows whoever claims the dependents.
Gotcha. Okay. So we mentioned earlier, and then one of the questions is, and I'll try to answer a little bit and can get your thoughts as well, was the deductibility of alimony, which was agreed to in 2014. Is it affected if the payor is able to reduce the amount later? So here in Missouri, I can tell you that if you leave a judgment pre-change in the law, it may have been well before 2014, and you were deducting interest on the alimony, if you leave it alone, you can continue to do so. But once you make a modification here in Missouri, my understanding was that if you modify that maintenance, the interest moving forward from that newest judgment now removes the ability to deduct that interest, or not the interest, the payments.
So again, with the modification, that isn't some more of a CPA question. I do know that if you have a prior judgment, they do allow for that deduction of the payments. I'm not sure why a modification though would change it, and it might be partly in state law as well.
Yeah, I think it's what we're hearing is, I mean, it's a lot of uncharted territory as we continue to roll into some of these modifications. And I think that the IRS, what we've been hearing is looking at a new judgment as a kind of a start over. And they're not going to continue to grandfather old judgments once they've been modified. So it's just one of those cautionary tales of get your family law attorney, get a CPA involved, take a look and see if you can see some opinions in terms of what the IRS is saying on those issues before you modify, and really weigh the impact and what it's going to do. And I think that's important. So I'm curious, John, have you ever had that issue in Georgia?
Haven't had it come up yet.
Right.
So, so we'll see what happens if and when, but yeah, that would definitely be something you would have to think about, because if they are getting that tax benefit,
Mhm.
how much lower would they have to be able to get their alimony payment to even make it worthwhile if they were to lose that tax benefit?
Right.
But I'll definitely, to the extent that comes up, we definitely would, talk to a CPA to get some advice about that before moving forward.
One other question is, and I'll answer, and I'm curious from both of you, your perspective as two kids going through a divorce. We've always kept our finances and taxes separate. We usually each take one child to claim and are continuing to do so. No alimony or child support. Is a structure okay to do? Pros, cons. Well, I can tell you that it's generally, I've seen people do that, and obviously post divorce, it is common, at least here in Missouri, for us to allocate perhaps a deduction. We may have three kids, one may get two, or each may get one, and then you alternate a deduction. We really do an analysis and a tax analysis to determine what's the most effective place for those deductions in terms of, you may have an unemployed spouse and a highly comped spouse, and we have to figure out, let's not give the government any money and leave it on the table. Let's make sure we can do that. But obviously curious, I'm not sure what the pros cons would be other than an economic, analysis in this situation.
So the pro is it's easy. And then as long as everybody follows it, it's not going to be a problem. What keeps attorneys employed is when people don't do what they say. Where they change it, the situation changes, and all of a sudden someone's claiming all three kids where they agree to only claim, one or two. That's what I see. And then that's the complaints that I get, look, we have, and if it's 50-50 custody in these cases, the IRS is not going to step into the middle of it.
Yeah.
So that's my advice is generally go modify child support, let them claim it and modify child support, because that goes straight into the modification or into the child support calculation pretty much everywhere I've seen.
Yep. And the last question we have for our time, a little bit confused by it, but let me kind of see if we can parse through it. It was, what is the process in satisfying the IRS when one of the, and it says MSA, settlement agreement, refuses to agree with the other on the split of the finances? It may mean one of the spouses refuses to agree with the other on the split of the finances. So again, I think this bleeds into, I'm curious, like offers in compromise, trying to figure out how do we pay the debt. The IRS, again, is not going to care. And maybe then settled in family court if you have to go back for motions to compel or enforce or contempt. What do you say?
That's a great question, because this is one area where the IRS will hold off pending the division of assets and divorce. So they will usually give it time, see how things are going to be divided before they actually demand that people turn over assets. This is where you might go in and negotiate a temporary installment agreement or hardship status to buy time with the IRS. But I've seen them hold off for years while divorces got worked out and eventually settled. But you do have to deal with those issues eventually.
Right. All right. Well, that is all the time we have. It goes very quickly. I appreciate joining, Hubert. It's always good to have an expert on things like taxes, because way outside of my comfort zone. We deal with the division of some of those things, but we get into the details. We have to hire experts like you. So where can they reach you if they have questions?
GuardianTaxLaw.com or 520-485-7371 is our main office line.
Great. Hubert, Deanna, thanks again for joining. I appreciate it.
Thank
Thank you.
you.
Well, continue to tune into our Men's Divorce Podcast live. Watch for those updates as we continue to do this each month. And we also do recorded podcasts under Men's Divorce. You can find that by subscribing at Apple iTunes. You can go to the YouTube channel, which is containing all of our previous town halls. Now moving forward, our podcast live, as well as a recorded podcast. You don't want to miss those. Check us out as well on all social media, or go to cordellcordell.com. Give us a call at